Craig Pennick versus Victoria Pennick.
Court will note that this matter is before the court on the plaintiff's motion by the presumed father to determine child born out of wedlock. In this matter, I assume, Ms. Pennock, you are not disputing or contesting this?
No, I'm not.
Okay. Well, what's going to happen is he's filed the motion. The motion does appear to be in order, but we don't take testimony on Monday mornings because we usually have a tremendous amount of hearings. We have to have those hearings on a Wednesday afternoon at 1:30. Have you done, Mr. Pennock, have there been any DNA testing in this?
No, I believe we don't need DNA testing because Tori and I have not been together since 2021, March of 2021.
Okay. Well, I didn't have in the file. Now you don't put in the date of birth of the child. So when I see the petition, I don't know when the child was born. So I don't know any of that. So
Yeah.
what year was the child born?
I'm
So the
still
child,
pregnant.
yeah,
Oh.
the child hasn't been born yet.
Okay.
Yep.
Well, what we'll do is we'll set this matter for a Wednesday evidentiary hearing, and we'll have you in at that time, and we can take some testimony. Okay.
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 So just contact my office and let us know when you're available on a Wednesday, and then we can proceed at that time.
All right. That sounds like a plan. Thank you.
Okay. We're probably looking at a week from Wednesday, only because we have a lot of those hearings on this Wednesday, but I think we'll be able to get in a week from Wednesday.
Okay.
Okay.
Yeah, we'll make
Thank
sure to
you.
call and get that set up. Thank you.
Yep, call us and set it up, and then let Ms. Pennock know, and so that she can appear and render some testimony as well.
We did have maybe one more question.
Okay.
Just about what other paperwork we might be looking at just to finalize everything after we do the testimony.
Did you, I think you, based upon the petition, you've got that under MichiganLegalHelp.org, correct?
Yes.
When we give the ruling at that time, or you can get a order, and the order is right after your petition, you can just kind of fill that in and then get that to us before the hearing, and then we'll be able to get that order entered on that date.
Okay.
So
We did also have one more question. I'm sorry.
Sure, go ahead.
I was talking with my health insurance, and we were hoping to have Tori continue to stay on my health insurance to help with the baby and everything. My insurance company just mentioned something about a possible, court order for that, to let them know that we would like to continue to have her on my
Well,
insurance.
let me tell you, the court that has no authority to grant an order a company to continue to maintain insurance.
Oh, okay.
I will tell you, and that may come into play on the when you want to finalize this, but if the court enters an order determining that that child with whom she's pregnant is not issue of this marriage, a child born out of wedlock, the insurance company will not cover that child.
Oh, okay. All right. Thank you.
So I don't know when she's due. When are you due, ma'am?
I'm not due until January. We're in an odd situation because it's an amicable divorce. So like I'm actually upstairs and he is downstairs right
Okay,
now.
I understand. I'm just
So
saying. I'm just saying what happens is you may want to put off that hearing that I was saying for a week from Wednesday, because once I enter that order determining the child's not issue of this marriage, I'll almost guarantee, although we don't guarantee, but I'll almost guarantee the health insurance company will not cover that child.
Well, so it's not the child that we were looking at having covered. It was just to continue for me. So I had insurance for the remainder of my pregnancy because I'm a stay-at-home parent. So I'm on his work insurance. And he
Okay.
did call and talk to them, and they said that they had no issues continuing to cover me if they had a court order. That was more what it was, so that I'm not without insurance for the last 3 months of my pregnancy, because I'm due after renewal point for most insurances in January.
Case is 187 days.
Okay, okay. Well, again, what's gonna happen is if we enter the judgment, because we could enter the judgment now, it's been more than 180 days. If we enter the judgment without an order stating that the insurance has to continue, they will take you off the insurance, and I will tell you, sir, what they're probably gonna do, the insurance company will probably come back to you and say, hey, you have to start paying for her portion of the insurance.
Yeah. Okay. I'm sorry. I'm not sure then what to do.
That's fine. I can look into something. So I know we're also
Why
trying
don't you
to-
talk about it, but as soon as we enter those orders, I can guarantee that your insurance coverage is gonna change.
I mean, I do have Michigan Medicaid as a secondary because I have no income. He just has
Okay.
got, so I've got it, that's where it's a little confusing because I am on Medicaid as a secondary because I'm pregnant and a stay-at-home mom going through a divorce, but I'm also on his like work insurance. I think we were
Okay.
hoping today to kind of just see if we could get more answers. It's like, he's not the father. There's no way he could be the father. So we were trying to see if there was a way, if the judgment is entered before she is born, then the birth certificate issue is what we were looking at because we don't want him on the birth certificate. He doesn't want to be on the birth certificate. Would that mean then that he wouldn't need to be put on her birth certificate if the judgment goes through before I have the baby?
Well, we can address that. Why don't we do that is we'll address that. Why don't we just keep it on? Let's do it. Call my office, make sure we can do it. We'll do it next Wednesday, a week from Wednesday. And then maybe we'll have more time. We can filter some of this out because I have other hearings that I'm waiting on. at this
Okay,
point,
yeah.
too.
Yes. All right. We can do that. Thank you so much.
Okay, thank you. Have a good day.
Thank you.
You too.
You too.
Bye.
Calhoun County Foster Care and Nicole Brown versus Matthew Brown.
I'll ask you, we did not have, I know you submitted a DNA test report, which was a home health DNA test from Genovat. You understand that?
Yes.
Okay, you understand that is not admissible in court as it is not, does not follow the criteria necessary to admit a test like that because it's not, first of all, it's not signed by anyone. It, again, does not confirm that it is a valid test as required by statute, and that is to in this matter. So I guess I'll ask you at this point if you, is there a reason you didn't have a valid?
Because the last court hearing we had, you said I can just get one from the store and do it at home instead of going through front of the court because it would take longer.
Well, okay. The problem is you can do that, but the problem is it's not admissible. So I can take some testimony today. We'll take the testimony that we can and determine whether it's sufficient. If it's not, then the court would make you then proceed with a valid test at that particular time. So,
Okay.
Ms. Brown, do you wish to make an opening statement or simply proceed to proofs in this matter?
I say I'm gonna say what I said last time is pretty much, well, I haven't been with Matthew Brown since 4th of July of 2020. And
Okay, hold on.
hold
on. I was asking if you were going to make an opening statement. If you're going into testimony, I'm going to have you sworn in first. So,
Okay.
do you wish to make an opening statement?
No.
Mr. Brown, do you wish to make an opening statement?
No.
And Mr. Taylor, do you wish to?
No, I do not.
Thank you. Ms. Brown, we'll proceed then to proofs. If you would raise your right hand, we'll have you sworn in and then we'll proceed.
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Thank you. Go ahead and tell me what you'd like me to be aware of, Ms. Brown.
I left Matthew Brown on 4th of July of 2020. I was with John Taylor from the beginning of November of 2021 till the end of June of 2023. He's the only person I was with for almost 2 years. He is Xander's dad.
Okay. And just because I'm going to need that, what is the date of birth of the child?
March 30th, 23.
And since Xander was born, has Mr. Brown had any relationship with Xander?
No,
Has he accepted any financial responsibility for the child?
no,
Has Mr. Taylor engaged in a parent-child relationship with Xander after his birth?
yes.
And what kind of things has he done?
Well, we separated in June, but he takes some he's been taking them on and off. We don't have no scheduled days. He helps provide for him. When we were together, he was watching them while I worked.
Okay. And did he accept and provide financial support for Xander when you were together or after that?
Yes.
Has Mr. Taylor ever contested or disputed custody of Xander?
No,
Yeah, I think I said custody, I meant paternity in this matter.
no.
So the time of conception of the child was approximately October of 2022, is that correct?
It would have been like, I think it was around, he was supposed to be due in April. He was a preemie. So I'm pretty sure it would have been around July, August of last year.
And he was due when, in April?
Yeah, he was due towards the end of April. He was born at 37 weeks.
Okay. So at the time of conception, you were not engaged in any sexual relations with Mr. Brown, correct?
No,
And at that time, you were engaged in sexual relations with Mr. Taylor?
yes,
Okay, thank you. Is there anything else you'd like to add, ma'am?
no,
Mr. Brown, do you have any questions of Miss Brown?
I do not.
Mr. Taylor, do you have any questions of Miss Brown?
No, sir, I do not.
Thank you. That will conclude your testimony. Mr. Brown, I'm going to have you sworn in. If you'd raise your right hand, we'll take some brief testimony from you.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
You'd heard the testimony of your wife in this matter testifying concerning your relationship. Is in fact her testimony accurate and correct?
As to my knowledge, yes, it is.
Okay, so you did in fact leave and separated on or about July 4, 2020?
Yes, it was exactly on July 4th.
And after that date and at the time of conception, which she stated would be July, approximately July of 2022, you did not engage in sexual relations with Miss Brown, is that correct?
That is absolutely correct.
And is it accurate as well that you've not had any relationship with Xander anytime after the child's birth?
The only relationship I had with him was I held him one time.
And you've not taken any financial responsibility for the child?
Absolutely not.
Thank you, sir. Do you have any questions of Mr. Brown, Ms. Brown?
No.
Mr. Taylor, do you have any questions of Mr. Brown?
No, sir, I do not.
Okay, thank you. Mr. Taylor, we're going to take some brief testimony from you. So if you'd raise your right hand, we'll have you sworn in and then proceed.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes,
Mr. Brown, or Mr. Taylor, you've heard the testimony of Ms. Brown in this case. Does her testimony appear to be fair and accurate?
yes, sir, it does.
And at the time of conception of the child on or about July of 2022, were you engaged in sexual relations with Ms. Brown?
Yes, sir, I was.
And since the child was born in March of 2023, have you engaged in a parent-child relationship with Xander?
Yes, sir, I have.
And what kind of things would you do with Xander?
I take care of him, watch him, like Nicole said, while she was at work. And after we split up, I have continued to watch him and take care for him and make sure he's up to date for everything.
I understand if the court determines that you are in fact the biological parent, that that will include and you'll have various financial responsibilities for the child.
Yes, sir, I do.
Are you willing to accept that?
Yes, sir.
Thank you, Mr. Taylor. Ms. Brown, do you have any questions of Mr. Taylor?
No.
Mr. Brown, do you have any questions?
I do not.
Thank you. Ms. Brown, do you wish to make any closing argument at this time?
No.
Mr. Brown, do you have any closing argument to make?
I do not.
Thank you. Mr. Taylor?
No, sir, I do not.
Thank you. I'll conclude the proofs in this matter. The court will make the following determination that court is called upon to determine that the child is a child born that is not issue of this particular relationship between or the marriage between it's a DS, so it's not a marriage, between the Ms. Brown and Mr. Brown. In this particular case, the court will note that the testimony of Ms. Brown, which is determined to be accurate by both of the other parties in this matter, is that on or about July 4th, 2020, that the parties separated, that she had not engaged in any sexual relations with Mr. Brown after that date, that the date of conception of the child would have been approximately July of 2022, that at that time she was engaged in sexual relations with Mr. Taylor, that following the date of birth of the child, that Mr. Taylor has taken responsibility for the child, both caring for the child personally and also taking financial responsibility, that he has not ever contested paternity in this case, and in fact acknowledges that he is in fact the biological father of Xander Taylor in this matter, born in March of 2023. He has acknowledged, Mr. Taylor has testified that Ms. Brown's testimony was fair and accurate, that he is engaged in a parent-child relationship with Xander after the child's birth. He continues to care for Xander, and again, will accept financial responsibility for the child. That being said, the court will, pursuant to Michigan Court Rule 722.1441, determine that, in fact, Xander is a child born out of wedlock, not issue of this marriage, and in fact, that the biological father is John Robert Taylor. And that will conclude the matter. Court will prepare the appropriate order and fill that out. And anything else, Ms. Brown?
No.
Mr. Brown?
No.
Mr. Taylor?
No, sir.
Okay, Thank you all. The court will end this hearing at 2:45 PM. You're free to go. Have a good day.
You too.